Do you have any insight into the FBI raid seizures of safe deposit boxes at U.S. private vaults in Beverly Hills? Yes, I do. There is a huge update on this. Last week, the Institute for Justice won a unanimous verdict from the Ninth Circuit Court of Appeals, holding that the FBI's execution of search warrants on private vaults, where customers rented private safety deposit boxes, much like a bank, that the individual searches of those boxes without a warrant was absolutely illegal. And this had ramifications not just for inventory searches, but also for forfeiture laws, which you know, of course, I follow all the forfeiture laws because I fight these forfeiture cases. But let's talk briefly about inventory searches and how they've been abused. Inventory searches came about in 1976 in the case of South Dakota versus Opperman, where a car was towed from the scene where somebody had been arrested and was being taken in to be impounded. The U.S. Supreme Court allowed a search of the vehicle to ensure against claims of loss, like you've got Picasso's hidden in your trunk or something, or money in the console. We don't want those things stolen or claims of loss being raised against the police, so a community caretaker function to protect against claims of loss was permissible. Also, there might be items that are dangerous to the police, explosives or knives or guns or something like that in the vehicle might pose a risk of harm, so police are allowed to search for those things if they're taking the vehicle into custody. Fast forward to 1990, Florida v. Wells is handed down, where the U.S. Supreme Court addresses whether or not something is within the policy, within the inventory policy. There was a suitcase in Wells that the police opened up to see what the contents of the suitcase were. And because it wasn't part of the standardized policy to go into locked or closed containers, the U.S. Supreme Court held that's outside the scope of an inventory search. As a consequence of that, what we have now seen across the country are the development of inventory search policies that are just absolutely asinine. They tell local police departments, local police officers, as a matter of policy, if you arrest somebody and there is a locked safe inside that car, you must break into that safe in order to ensure against claims of loss or potentially dangerous items being contained within that safe. The safe is then searched inside the car, it's broke open, and the contents of whatever's in that safe are now admissible evidence under the community caretaker function of an inventory search. And I'll tell you what, once you tell police departments you have to write a policy and that policy is to do X, Y, and Z, they're always going to draft a policy that attempts to circumvent or get around a